Let's welcome Anna Kamateros, who is a native of Montreal. Anna started her career as a social worker in the healthcare system, where she gained extensive experience working with families and especially with the elderly. After graduating from University of Montreal, she did her internship and started her career as a notary at a prominent legal practice in Montreal, where she specializes in matters relating to families and also gained an expertise in title issues related to commercial and residential properties. She was also handed the responsibility of executing all the deeds related to condominium project comprised of 85 units. Currently, she is in private practice and is finishing her master's thesis in law and on the role of banks in preventing elder financial mistreatment. So without further ado, I'm going to welcome Anna.
Hi, everyone. I'll try and keep it somewhat brief to leave time for questions afterwards. But I think it's a topic that a lot of people usually have a lot of questions about, and I'm going to try and focus it on the mistreatment factor of wills, mandates, etc. So just to open on that note, something I'm often consulted with is the following scenario. So this is somewhat of a scenario that keeps recurring, especially as of late. Someone older, isolated, lives at home alone, doesn't have family that comes to visit that often. A neighbor, let's say, starts doing a few jobs here and there for the person at home, gets closer and closer, develops a relationship of trust, and one day shows up with his or her notary and has the person sign a bunch of documents. And that could be a will, mandate, and a power of attorney a lot of the time. And that's something that does happen, and we're consulted to it is something that can be corrected at least. So the point of today's presentation is to make everyone aware of the types of wills and mandates and powers of attorneys, the difference between those three documents, the importance, the legal aspects, and also to encourage everyone to really consult, ask questions, and know what you're signing before you sign it. So, brief overview over a will. So the point of a will is to choose your heirs, choose what they're going to receive from your estate, to have control over what's going to happen to your property after you pass away. There's different types of wills according to law. There's the holograph will, which is a handwritten will a lot of the times. There's a will done before two witnesses, which is initialed on each page and signed before two witnesses on the last page with an affidavit by the witnesses as well. And there's the notarial will, which is completely signed before the notary, and is prepared by the notary. The advantage of the notarial will, as opposed to the other two types of wills, is that it's not subject to probate. And a notary by trade, we're supposed to ensure that the person in front of us understands and is comfortable with the documents that they're signing. So there's an extra security there. So passing away without a will. What happens when we don't have a will? A lot of people think the government's going to take my money if I have no will. That's not true. What happens is that the law, our civil code, provides for different orders of heirs. So the first order, let's say, is the spouse and the children. And in Quebec, you have to be married to be considered a spouse according to law. Common law spouses cannot inherit unless there's a will. So the spouse would receive 1/3 and the children receive 2/3. If there's no spouse, children receive everything. If there's no children, then the spouse would share the estate with the siblings and the parents of the deceased. If there's no spouse, the siblings and the parents would divide that. And then we can keep on going, so on and so forth. Sometimes what happens is that we have to hire private investigators if someone passed away without any immediate family members to find extended family members, which we want to avoid. It's expensive. So again, in all cases, common law partners do not inherit. So what's a liquidator? One of the main reasons to do your will is to choose the executor, which in Quebec is it's known as the liquidator in our civil code. That's the person who has control of the assets once the person passes away, who clears the estate, pays the debts, etc., and has the most important role actually when dealing with an estate, and has a responsibility towards the heirs and the estate. You can choose one, you can choose several, but it's an important choice. If you want to ever leave to minor children as well, that would have to be taken into consideration when speaking with your legal professional because it would be left in trust. Minors cannot inherit according to our laws. It would be subject to a review of the public curator. So it's something to be considered when speaking with a legal professional about your will, about estate planning. So now going into the mandate. So one thing just to close the loop with the wills, because I am going somewhat fast. Important to be clear about your wishes and be clear with your family. If you want to disinherit one child, let's say because he's done so well during their lifetime and the other child, your other child is a bit more needy, let's say, or is requiring more assistance, just let that be known to the children because a lot of the times what we see is that the child who wasn't left anything in the estate, if nothing was mentioned to him or her during the deceased lifetime, they're going to feel slighted. They're going through the grieving process. It becomes a bit of a family fight. So it's just something to keep in note. So now this is even more important actually when we're talking about elder mistreatment, is this idea of the protection mandate and the power of attorney. So one thing that I really want to make clear before we even talk about a protection mandate is the difference between a power of attorney and a protection mandate. So a power of attorney, from the minute you sign it, you're giving that person the right to do whatever you're mentioning in that power of attorney from the minute you sign it. So it's not subject to any kind of incapacity. So a lot of the times people will sign a general power of attorney, which gives vast powers. Technically speaking, the person to whom you're giving that authorization can go and empty your bank account the next day. So it's something to keep into consideration. It's something to be done specifically most of the time, a power of attorney, and it's not something to be taken lightly either. Whereas the protection mandate is a legal document whereby you choose who will represent you in the event of incapacity, and that's legal incapacity. So it's subject to a court judgment, and you hope to never use a protection mandate, to be completely honest, but it's there in case you wish to set out how you want to be represented, who you want to represent you, and what are your wishes in the event of incapacity. Importance of having a well-drafted mandate, and that falls into the stream of today's discussion in a sense of understanding and knowing what you're signing before you sign it. So it's different than the liquidator. The person you choose in your protection mandate, the mandatory, is not the same as the liquidator who you name in the will. A lot of the time people think, well, I named an executor in my will, they're going to represent me in the event of incapacity, but that's not true. And don't settle for templates ever. Don't settle for a form because those just give vast powers without even any kind of consideration to each person's unique situation. So here, this is what I was mentioning, that a protection mandate is conditional upon a judgment declaring a person legally incapable of making decisions. Again, power of attorney, it's important to know that it gives vast powers from the minute you sign it. Then this is the procedure according to law to homologate a mandate, which I'm not going to go over now because we have limited time. But if there's any questions, and this PowerPoint can be disseminated, I don't mind. So you guys can receive it if you wish. But it's something that could be done before a notary if it's not contested. And that being said too, don't be forced or pressured into doing a mandate in case of incapacity, so protection mandate. If you don't have a protection mandate, what happens is that we do another court proceeding, which is a protective supervision. It's either a curatorship or a tutorship. Can become a bit confusing, but that's a protective type of regime in the event of incapacity because the public curator has an overseeing role as well as a tutorship council. So there's more checks and balances when we do a protective regime. So if you're not sure about who you would want or how you would want to be represented in the event of incapacity, don't feel pressured to do one. That's one thing I want everyone to leave with today, because that could open the door to mistreatment as well. There's just very simple differences between the procedure, and this is just my information. So I'll leave the floor to Anne now, because I know we had limited time. Is that okay?
we'll bring her back. We'll bring Anna back, and you can write out your questions for both ladies, and somebody will go and pick them up, and we'll go into a question period. So first of all, I want to introduce Maitre Soden. She's basically Canada's expert on legal matters revolving around elderly people. Anne is the founding chair of the National Elder Law section of the Canadian Bar Association, a writer, editor, a conference speaker on issues and problems of aging and how they can be resolved and prevented in multidisciplinary, client-centered, human ways which avoid court and promote dignity, autonomy, and quality of life for older persons. In 2007, Anne opened the Clinique Juridique des Aînés, the Elder Law Clinic, a pro bono mobile clinic and pilot research center serving older adults through the province of Quebec, and teaching clinical practices to law, medical, and social work students on legal issues and the multifaceted challenges of aging. Also in 2007, Maitre Soden was designated an advocate émérite by the Barreau de Québec for her contribution to the legal profession, society, and the law throughout the development of elder law in Canada. In 2017, she was the inaugural recipient of the Lord Reading Access to Justice Award conferred by the Minister of Justice of Quebec. And Anne is going to be speaking to us today about elder abuse, financial exploitation of family members, the most frequent perpetrators of mistreatment and exploitation of older adults, and of the injustices caused to the person and the divisions created in the family. Anne will illustrate how she avoids court, empowers the older adult, including the older client with impaired capacity, and works to preserve and repair family relationships wherever possible. So without further ado, I welcome Maitre Anne Soden. Thank you very much, Anne.
Good morning, everyone. In 5 minutes, we'll cover this whole subject. Really, we want to leave time open for questions. And I think it'll go first to lunch and then questions to follow, Ruth?
If you would prefer to do that, that would be fine.
No, we're fine, whichever way it works for everyone. All right. All right. Well, that description of what I do every single day is, in fact, all of it. We're dealing every day in our clinic with problems that arise for people as they age. Anna deals largely with planning for later life, the very important considerations that we have to make as we age. And in fact, people who are young should be thinking about these things as well. It's not when you're aging that you think about them. But let me say in general, in terms of planning for aging and drafting these documents, that they need to be complemented with, to avoid problems that come up later, communication, speaking to your family. As Anna gave an example of what can happen if you haven't spoken and you've denied one child an inheritance because you have somebody who's disabled in the family or somebody who's more needy in the family and have not realized the consequences that can bring. It brings terrible, terrible grief that lasts. It's the worst legacy that you can leave a child. But there are other matters that can come up. There are all kinds of divisions and misunderstandings that arise. And those misunderstandings come to play perhaps when one spouse dies and the other one is left very vulnerable. And it can be brought by the children. And indeed, universally, family members are the most common perpetrators of abuse and mistreatment. And the misuse and mistreatment is very pervasive, but very subtle in most cases. And so we want to address these. They are at the base of this mistreatment, legal rights, rights of dignity, and independence and autonomy that have to be respected. They're fundamental, and they're contained in our Charter of Rights, both in Quebec and in Canada federally. So working on these matters are probably the most noble of causes that we have, but they're not easily perceived. That if somebody is being spoken to or spoken down to, a family member is speaking down to an older family member, infantilizing that person, saying, you can't do it, it's now time for me to do it, you're not capable, you know, you're crazy. Those are not just hurtful, but they are absolutely illegal acts. And so they're not traditionally the matters that come into the hands of a lawyer. They're often the situations that go just hurtfully along, and the person is deprived of the recognition and the dignity that they deserve. Along with this kind of berating and infantilization and manipulation, that is the most common, universally, the most common type of abuse is psychological abuse. Comes denial of rights. And that denial of rights is unfortunately very, very prevalent in our society. And it happens with good intentions by a variety of people, including professionals, doctors, social workers, people who run residences. They think that they're caring for the person, they're protecting, but they are overprotecting the person. They're denying them their right to make their own decisions. Those people who are financially exploited are regularly and systematically viewed as incapable. How could you allow yourself to be exploited? We can all be exploited, any age, particularly older people who are constantly solicited, all the time solicited, berated with calls and so forth. But closer to home, it can be simply the child of that older person who takes over and then considers that they're entitled to take money. And if there's no oversight, which is again something that Anna takes care of in terms of making sure that there's monitoring that is inserted into these mandates by a third party, that there is accounting that goes on, and that the person who is stepping into the role realizes that they are there at the instruction of that person who has named them, and that they are in every way to allow that person to participate, to have complete autonomy in every way for every single decision that they can make, and certainly to be reported to in respect of any handling of their finances. So there's a great deal of education that needs to go on by all of us, and a great deal of respect that just has to be brought home. It's fundamental. Many people that I deal with who are family members, I say, my goodness, you don't need to know the law. You are doing instinctively what is right and required by the law when you're acting so beautifully and so respectfully with your family member who has dementia, maybe even advanced dementia, but that person is treated with ultimate respect, allowed to co-sign the check because that's what they always did, go to the bank, have their little account, go and take out money from the cashier at the desk, which is becoming a fading practice, but just because that's what she always wanted. Reported to every week by her daughter about what has been spent and how, the checks have been signed, and here, Mom, is exactly what has been done, and keeping a track of that, having supporting documentation. There are some people who do that just automatically. They don't even have to be told. They've been so well brought up, and they are so respectful of their family members. So that kind of fundamental teaching we try to bring home not just in Anna's case before the fact, but where problems arise, we try to bring the family together to say, without pointing the finger at the person who's been taking money, but using a very respectful manner of repatriating that money, if not in this lifetime, certainly at the time that the estate is unfolding down the road, that person, there'll be an equalization at that point, where that person who took money thinking they were entitled to have that money before they were to pay it back. It becomes an accounting entry, and it is paid back in that way. We try to bring family together to say, your mother was subject to this exploitation, but she has rights to be recognized for her full capability, usually. In most cases, a person is very capable, but just had succumbed or was an enabling parent and succumbed to giving money to one child to the point where it was really threatening their viability financially. And members of the family intervened, or someone else on the outside intervened. But too often they're quick to judge that the person is necessarily incapable, and the only way to protect them is to take all of their rights away and put them in the hands of somebody else. We have to avoid that rush to judgment. We have to put the person back on their feet, help them out, assist, support the person, but make sure that we leave them whole. And even those people who are declining, make sure that we keep them whole. So that, in a nutshell, is what we try to do every day. And I'll look forward to receiving questions with Anna.
Any questions been written out? Are monetary gifts taxable in Canada and in the United States?
It's a multifaceted question. Inheritances are not taxable in Quebec here, but in the US, most of the time they are taxed. So if you have an heir or someone you want to appoint as executor who's a US resident, proceed with caution. There's usually issues there, especially when appointing an executor who's a U.S. resident, because it would make the estate deemed a U.S. resident as well. But these are getting technical, these aspects. And then an actual gift, a monetary gift, just a gift in kind, it's a gift, so no. But that being said, if it's a house, a lot of the times, or a property, then yeah, there's tax issues there most of the time.
Gift in kind in the States is not taxable?
Well, a gift in kind is while we're still alive. Let's say like money, like just money, it's just cash. It shouldn't be taxable at that point. In the U.S., I can't give an opinion about the U.S., but inheritances are usually taxed in the U.S.
What can you do if you suspect or know an elder who has been taken advantage of by a family member?
That's difficult. Because you have to have that person's consent to contact someone. So it's very difficult to make just a blanket statement. And I would have to have a particular case in mind. So the person who asked the question, if you have a case in mind, will certainly be prepared to speak to you, because that comes up all the time. But a neighbor, for example, might call a neighbor or a family member or a social worker, may call us at our clinic and say that there is a problem. We really suspect that there is elder abuse by a family member against an older family member. And in that case, we have to have the consent of the person before we can go in to see that person. Sometimes it'll be another family member, let's say the good family member, who brings that person along to meet me. And if I feel that the person is capable of communicating on a very simplistic level, it doesn't have to be a complicated level. I'm not there to do a doctor's evaluation, but I can tell right away whether that person is seeking help. Yes, I don't like what my son is doing. He's taking some money I don't really understand. Say, well, may I speak then to your son? And certainly in the process of calling the son and organizing a meeting and making sure that that person is not going to be attacked by the son in raising that question, because we don't want the person to be thrown back into into a situation where the son is going to be attacking the mother for having dared to call or have been communicating with a lawyer. So it's often very delicate, but we make sure that that person consents to want to have help, is then evaluated by a doctor to make sure that they can communicate sufficiently to want to have some help, and we right away make sure that the family is pulled in together to realize that that is the person's right.
If you're changing executor in your will, can I just add a codicil?
Yes, I would suggest you go to the same notary you went to for the original will, mainly because afterwards certified copies are going to have to be ordered and you don't want to have to go to 2 different notaries. So yes.
I want to sell a timeshare in Florida. Can you recommend a suitable person to help explain why it's difficult sale? Well, we're talking the states, and this is really not Anne's.
Well, no,
Yeah?
it is.
Okay.
But it's Anna who has contacts and communication across borders
Okay.
with experts that are notaries and lawyers who deal with this
So
matter.
do you have an answer, or would they contact you?
You'd have to contact a lawyer or like a real estate lawyer. Usually if it's in the US, it's a real estate lawyer about selling that timeshare. And then we would collaborate from here. But
Is there a way to cancel a second liquidator? She is very difficult to contact to sign bank deposit and withdraws.
yeah, well, this is, I guess, for both me and Anne to a certain extent, because if we're talking about an estate that's been opened and one of the liquidators is blocking the movement of the estate, then you have 2 options. Either the person can resign, which would be the easier of the option, renounce to being the executor by notarial deed, or if they refuse, then they're causing a harm to the estate. You could technically take them to court and ask for the judge to remove them as liquidator, which is not ideal in any scenario. A lot of the money from the estate is going to get used to do that. Mm-hmm. So ideally, it would be a matter of trying to get the other person to resign themselves since they're not fulfilling their duties.
Anytime you go to court, it's very costly.
Yeah.
Estate litigation pays lawyers, accountants, and experts, and it decimates an estate. So we try to resolve matters as best we can.
So I think thank you very much, Anna and Anne.